Welcome to the Practice Podcast, a show created by lawyers to help lawyers in life and business without all the complicated lawyer language. Let's welcome Bast Amron founders and your hosts, Jeff Bast and Brett Amron.
Today, we wanted to talk about one of our firm's core values, which is communication. We communicate.
So we want to communicate about communications.
Yeah, that's exactly.
All
We
right.
are going to communicate today about communication. We have our core values written. They're on our website, and they're on a wall in our office and in various places. But communication is one of those that I think just seems obvious to people, but it's just so fundamental to everything we do. As lawyers, I would say it's fundamental to any business or any organization whatsoever.
I would say it's
communicating.
fundamental to personal interaction
life.
too, right? To life as
Yeah.
we know it, right? Miscommunication, failure to communicate,
Right.
100%.
Yeah. I guess it's fundamental to any relationship that you have, whether it's personal or business or otherwise. And I think as lawyers, if we focus it on lawyers, we have many different methods of communication, but we also communicate in different ways to different people. The way we communicate to a judge is going to be different than how we communicate to each other or to a client or to opposing counsel.
Yeah, our job is to distill down information to convey a position, like you said, to varying audiences. And we have to, that's kind of central to what we do. And we have to decide, I think, number one is, do you communicate, right? That's the first part,
Right.
which
Whether
to communicate or not, right? And I'm always surprised, been doing this for a long time, as have you. I'm always surprised when either clients come to us or we're in a case or in a matter and there's opposing counsel and there is no communication or
Right.
very little communication. I'm really surprised by that. So I guess that is an issue, whether to communicate. How do you communicate? What's the method that you use? Because depending upon the issue, depending upon the individual or individuals you're communicating with, and depending upon number of different factors, like the method of communication matters. And
So you mean like by email or phone?
yeah, pick
or
up the
writing,
phone,
right?
or nowadays it's video chat more so, right? That's taken on a life of its own. Or is it an email, or is it a letter? God forbid you actually send
Fax.
paper. Yeah, no, fax is dead. But do you send a letter, paper? Or do you send a handwritten note, which is always nice to receive these days? Do you pick up the phone to call somebody, or I guess text message? There's varying methods to the communication, and then what's contained in that communication. And to me, all of it is important. And the methodology, we can talk about sort of that, and what is contained in the communication is super important.
Sure.
And how we communicate, like what's contained in there. I shouldn't say how. What is
the
contained in
substance
there?
of what you're actually saying and how
Sure.
you say it, right? So I agree with that, and I think if you go to the first one of those was whether you communicate, my answer would be always, right? I think it's almost always better to communicate. The only time I could think of, as you said that, when I might not want to, is sometimes strategically in litigation, we will not reach out to the other side because they may perceive it as a sign of weakness. But that's really only in very limited circumstances, and it's very case specific.
Yeah, that's a very old school. And I subscribe to that in some instances, but I almost like to disarm it and jump out in front of it and just let someone else decide why I'm communicating with them as a sign of weakness. But you can convey, and that's communicate to them.
How you communicate.
Right. It's how you do it. And what you're communicating to them and conveying to them should come across as, I'm not reaching out to you as a sign of weakness. I'm reaching out to you because I do think that we should communicate. And if you want to take it that way, well, that's up to you.
Right.
But I'm here conveying to you that this is not. I'm very confident in my position, but you know what? Our job is to communicate. And so if you tell me pound sand, then, fine. And then I can go back to my client with my head held high or even a judge and say, Your Honor, we reached out, we attempted to resolve the issue or to work through the issues, and we were just unable to do that.
Right. Yeah, but at least you tried.
You tried.
And I agree. And I think you owe it to your client and to the court in the litigation context to attempt to resolve really all disputes. And it's always in our client's best interest, even when the clients, sometimes they don't think that. It's always in their best interest to resolve a dispute. And if it can be resolved by a phone call or a video conference or however, a mediation, whatever it may be, you should do that.
Yeah, I mean, listen, are there times when like, hey, let's just stand silent for a period of time? Sure. I mean, there may be, but that doesn't mean I'm not communicating at all. It means that I've communicated in one form or fashion, and I'm just not going to continue unless there is reciprocal communication, right?
Yeah.
We have following up. I mean, I do it, you know, probably to the annoyance of many, but that's our job. Sure. How would you feel if you hired a lawyer and you asked them, hey, have you reached out to the other side? Yeah, I sent an email about 2 weeks ago. And that's it? Yeah, that's it.
Or I called and left a message and that was it.
Yeah, I called and left a message and haven't heard anything back.
Right.
No, it doesn't work that way, you know, in my view.
No, I agree. And I think you attempt to communicate as often as you can or as appropriate. The only times, you know, the only times, as we were talking about, where you maybe stand still is even in that standstill, it's likely after excessive communication. So if you've tried and tried and tried and you can't resolve it, then you stop. But I think reaching out to the other side, having a conversation more often than not is productive. And the other side of this is also just talking to our clients. I think a lot of lawyers go wrong too, is they don't communicate enough with their own client. I know you've encountered it. We've encountered circumstances where opposing party receives a settlement offer, maybe from us, and they're not communicating it to their own client. They just reject it out of hand. And forgetting the ethical ramifications of that, which is it's obviously unethical to not communicate a settlement to your client. But I think any lawyer that doesn't keep their client informed and communicate honestly with their client is doing a disservice.
Yeah, obviously our method is to, quite honestly, sometimes over-communicate with a client and provide them with transparency and everything that, what's our mantra here is anything that comes in or goes out of this firm goes to the client.
Right. They should know what we're doing.
Right. And until a client says, please stop sending me all this stuff or telling me all this stuff, which I don't think I've ever had, then we stop, right? But the idea is to just keep them informed. Obviously, and this is what the substance, we'll get to number 3 in the list, is what you say in the communication rather than just see attached, which, you know, that happens too. So I'm going to send my client a 60-page brief that has just been filed and I'm going to say, see attached. That,
right. Or
to me, to us, like, or see attached order from the court.
Granting a motion for summary judgment.
I'll call you.
Is this good? Is this bad?
Right. Or just see attached. You know, there's got to be more to that communication and maybe even a call in advance of sending, depending on what the news is, good or bad. To me, I think you have to pick up the phone and say, all right, listen, just got this ruling. I want to preview for you that it's a good or a bad or it's indifferent or whatever it is. I'm going to send it to you. I want you to read it. And then we can have a substantive conversation about it. But I just didn't want to send it to you cold.
Right. Yeah. And especially if it's a 60-pager like that, I would even go so far as to direct them, depending on if I'm sending it to the client, I'm going to direct them to, you don't need to read the whole thing because these are busy people. They have other lives and they're involved in litigation. But the point is you're going to guide them. You're not just going to send it to them and say, read this.
No, and I meant more on the order. A ruling.
A ruling.
You know, I would say depending on how long the ruling is or, you know, whatever. But
that's a brief. I think that's a
brief, obviously 60-page brief. Listen, they just filed this. Generally, here's the, you know, the arguments they're making. Here's what our next move is. I suggest that you take a day or two if you want to absorb it, and then we can have a call or whatever the timing is. And then give them the timing, right? Like if there's another deadline that's coming up as a result of that, you let them know in that communication, here's what we're going to do next.
Yeah. And I think, you know, it looks like we've shifted over to the third one, which is the substance of what you communicate. And I think it's obviously probably the most important one.
Well, you don't get to 3 if you don't.
You don't get to 3 if you don't hit 1 and 2. That's true. I think what we say to our clients is, to me, I think of the most effective communication is the one that anticipates the response or the question. So try to anticipate what questions is the client going to have when you send that brief or order or whatever it is that you're going to send. So here's what I'm sending. Here's why it's important. This is the part I want you to read. And this is what our plan is. It's exactly what you just outlined. But I think that outline is driven by what you anticipate are going to be the client's questions.
Well, hopefully you've already, before the ruling has come in, or before the briefing, or before you file a motion, or you've already communicated with the client about, here's what we're going to do. Here's our strategy. Here's the potential implications of that. Here's the potential arguments in response. And so that nothing comes out of left field for them when it comes in, and you say, hey, as we discussed previously and anticipated, here's the arguments that they've asserted, or hey, there's a new argument they've asserted which wasn't anticipated. We're going to look into it and address it. And then here's the ruling, which we told you this was we discussed.
Right.
This was a potential outcome, and here's the outcome.
Yeah. I always like to draw medical analogies in our practice. To me, it's almost like a doctor sending you a message saying, oh, there's a tumor, period. And that's it. No explanation of what the risks are, what the plan is, or whatever. If you got an email from a doctor saying, we found a tumor and no other, call me, how would you feel? It's the same thing. If you get an order and a ruling in a case or a settlement, whatever it is, and you just send it to a client and say, see attached, well, okay, what does this mean? What are the ramifications? And you're just unnecessarily sending someone potentially into a stressful environment where they've already likely to be stressed by being involved in litigation or insolvency, or, and people are stressed when they have to deal with lawyers.
Yeah. I mean, listen, as natural as it seems to us to over communicate with clients, I know that it's not necessarily the practice of many lawyers. Right. And again, it depends on the client too. Just depends. Or client contact. If it's a major corporation, you have a particular contact at that corporation. Right. And so, but there should always be ongoing communication back and forth with the client. What becomes a little trickier and more strategic is communicating with opposing counsel, whether it's on a deal, whether it's in a litigation, in a bankruptcy. That to me becomes a little more difficult. Not that you don't communicate, you should communicate. It's the methodology.
Yeah, it's more strategic.
And what is contained in the communication. My view is before things get contentious in any litigation is to pick up the phone and reach out to opposing counsel and have a conversation, a call, or maybe a video chat now, and just listen. We're going to litigate over the issues. Hopefully that's all we're going to have to fight over.
Right.
And we can maintain what we should maintain, which is civility between us, and just deal with the issues at hand, no matter how contentious our clients might be, and try to get off on that footing with a particular lawyer that I don't know. If I don't know the lawyer on the other side, right? Or even if I do know the lawyer on the other side, pick up the phone and say, hey, got another one, and just move forward.
Right. Well, I think you do. Most of us do the same thing in the beginning of a case. We'll reach out to the opposing lawyer and introduce ourselves if we don't know them. And if we do, then say hello again and just share your view of the case and how you expect to litigate it. Because as you said, usually our clients in a litigation or in an insolvency are hostile to each other on some, not always, but oftentimes there's a dispute and that's led to litigation. That means they haven't been able to work it out. And oftentimes they either haven't communicated in a long time, or there's a sense of distrust or misinformation, whatever, we're having to overcome. But that doesn't exist between the lawyers. At least it shouldn't. We don't have the bad blood or the history that the clients have. And so it's, hey, if you need courtesies, I'm going to extend them, and I hope you'll do the same for me. And here's how I think the case goes. I hope we can get to a resolution. If you want to discuss a resolution, I'm prepared to, or whenever I think I might be prepared to. But I think setting the tone like that is super helpful.
Yeah, and I think we did a podcast a while ago on bulldog litigators and why that may not be in the best interest of the client. And I think communication goes along with that, right? And that doesn't mean that we're giving away the farm. It doesn't mean that we're going to be soft in terms of advancing our clients' positions and being strategic. It just means that my job is not to make the lawyer on the other side's life miserable. That's not our job. Our job is to zealously represent our client, to advance the best interest of the client, and to try to get a result for the client. Period. That's our job. And like you said, you give courtesies and you communicate when you can. And if you can't, then you communicate that.
Yeah. Right. I'm not going to be able to talk to you about this.
I'm not going to be able to
agree.
I will not be able to grant an extension on this one. And here's why, or if you can convey that, right? But again, that's the communication. Instead of just saying no,
right?
The response, like the tumor, one line, one word email is, can I have no? We don't agree.
Right.
Okay. Well, why?
Right.
Because by the way, that's going to be put before the judge.
That's a great one. Yeah, you should.
And not,
Let's elaborate on that. Right.
Yeah.
You should assume that if you're communicating in writing with the opposing party, I think it's your rule that is don't put it in writing if you don't want it to be on the front page of the paper, right?
Front page of the paper.
Exactly.
That goes not just for obviously the practice of law, but I've conveyed that to my children as well, which is on social media. If you're okay with it being on the front page of the paper,
right,
then send it.
And then they say, well, what's the paper?
What's the paper? That's right. And I have to show them, I have to go buy a paper and right. But yeah, if you're comfortable saying something in an email that you would say face to face to somebody and that you would be okay with it being on the front page of the paper, or that the judge would read it, like you're okay with the judge seeing that, send it.
Right. Because you should assume that it's going to be attached at some point in a contentious case.
Right.
You should assume their communications are going to be attached to a filing in court. Hopefully not, but...
No, but that happens.
You need to be prepared for that.
You got to be prepared for that. But keep in mind, if you're not willing to do it, then why are you saying it?
Right.
Even on the phone, why are you conveying it that way if you're not willing to say it in front of the person or to the judge or on the front page of the paper? Put it in writing. I agree with that 100%. And you should be mindful that anything you put in writing is going to be put before the court. But then why are you shouldn't even say it anyway.
Right, exactly.
On the phone. There's another way. We're lawyers. Our job is to figure out how to convey our position in a manner that others can understand it. So why do we have to get all, our backs up? And listen, I'm not innocent here. I've, over my career, I've done it. I get it. And there's times when you're heated and you're heated exchange and things happen. But I think through the course of time, you have to realize that may not be the best interest of your client. And that means maybe I'm not doing the best job as a lawyer if I can't convey in a civil manner, if I can't convey to the other side my position. Then maybe I'm just not good at what I do.
And if you're on a call and you can't, then say to the person, hey, can you hold on 1 second and take a deep breath and gather your thoughts and then communicate to them back, put them on hold for a minute. It's almost the same thing as before you send a hostile email. Yep. You should not send it, but set it aside and just take a deep breath before you send it.
Yeah. What do we always say? Like type the email and walk away.
Right.
If you're angry, if you're incensed, if you're, whatever, what someone else did or type the email, but walk away. And I always, if I do it, I don't put in the 2-line like who I'm sending it to. I just type the email. Yeah. So just in case it gets hit,
send,
you hit send,
mistake,
it doesn't go anywhere.
Yeah. No, I agree with that. Right. That's just to clarify that, just so everyone understands. So when you're writing that emotional or hostile email, don't fill in the recipient's information until the end. That's write the email so there's no risk of hitting send by mistake.
Yeah, because
we've all made that mistake.
Yeah. You hit send and you can't pull it back.
Yeah. And you and I have a pretty good practice where we have that situation. Oftentimes, I'll just run it by you or the vice versa and say, hey, what do you think about this? And usually when I do that, I'm expecting you to say, don't send it or to modify it. And sometimes you go, and I like it. It's fine. It's kind of like find that person who you can use as your conscience, as your kazoo from the Flintstones. As
what
somebody,
are the Flintstones?
Exactly. Right. As somebody who can be your check and balance on your tone or language.
Yeah. And just sit back for a minute and just take a deep breath, and maybe hit send anyway.
Right.
But those are the hard ones for sure. And listen, in court, sometimes things happen too. And we've seen it recently on TV and some of the trials that are going on. And, judges and lawyers will tangle and lawyers will tangle in court. And it happens in the heat of the moment. But our communication and conveying our client's position, our position is so important to what we do. That is what we do.
Yeah,
we're
that's our job. Right. And so clients hire us to advocate their position in a manner that convinces a third party to decide in their favor. Right. And sometimes the clients, we've talked about this, maybe even on other podcasts, but sometimes clients just need to be heard. They need someone to communicate their message because they feel like nobody's hearing them. And sometimes, in those cases, I always like to have the client in the courtroom so they can hear us make their case and they can hear the judge react. And especially, in more challenging cases, and especially in insolvency, we want clients to hear it directly from the judge.
100% agree. But I took out of that something that I did want to convey in terms of communication, and this always gets lost in communication or discussion on communication, which is everyone thinks communication is the outward expression, right? Whether it's writing or verbal or video or whatever you want to call it. But listening is a huge component to communicating. That's one, huge. We have,
For sure.
My saying around my house is God gave us 2 ears and 1 mouth for a reason, right? We like to listen more than we speak. We should.
Right.
And nonverbal, facial expressions, body language, things like that can also convey a position. That can be a form of communication as well. And I think as one of our recent podcast guests that hasn't come out yet, said in a meeting, if you're sitting in a meeting, whether it be a mediation or a meeting, back in the olden days when we used to actually do things in person, and you're speaking or someone else is speaking and you're listening and you're looking around the room, as a lawyer, you should be able to look around the room and get a feel, perhaps, for
read nonverbal cues, right?
Right. Read the room. And that's a form of communication as well.
Yeah. And that's why I'm looking forward to getting back to being in person. That's one of the reasons why I think in-person mediations, in-person court hearings are just better. And I appreciate Zoom or video conferencing as an alternative method. It's better than phone for sure, because at least you can make eye contact with the person, but you don't get the same verbal cues as you get in person.
Yeah. And look, Zoom is here and I think it's good for a lot and good to help the practice. But I agree with you. I think that for some of it, in person is just, thankfully we've got video as opposed to just phone. To me, phone hearings are just impossibly difficult unless it's really a routine ministerial thing that you're dealing with. But I think to get a sense of the judge, get a sense of the opposing side, get a sense of the parties generally, the people you're dealing with, to me, it's in person is far better.
Yeah. And the other side of that is just having in-person court hearings forces the opposing parties to speak and communicate. Right. So when we are in a virtual world where everything is by Zoom, the only way to speak to the other side is one side picking up the phone or video conference, however you want to, whatever the verb is there. But when you have to go to court and you actually have to physically go to court, you will see that opposing lawyer. So you are forced to communicate with them. And that's where, how many times do we resolve matters? We resolve cases in the courthouse, on the steps.
Sometimes people aren't as brazen in person as they are in an email.
That's for sure.
Yeah.
That's for sure.
Right.
Yeah, we could have a whole podcast topic on email versus phone or video. And I think you and I are both advocates of phone first or video first, phone second, email third. Email is really shit. I think most people fall back to email as their default mode of communication, but it really ought to be the backup.
Yeah. And look, certainly email is a good form of communication. It can be. But I agree. I think that verbal communication, face-to-face communication, whether it has to be on video or otherwise, is probably the best method.
Yeah. So I wanted to circle back to something else you said about listening, because I think you're right. That is...
Oh, you listen. You heard
communication. Exactly. I have 2 ears and I tried to use both of them. I think part of communication is an important part is not only the message that you send, but the message that's received. And it's not just hearing, because sometimes, and we've seen this, you and I can hear somebody else, our producer, Nelson Rosada, say something and we both hear something different. And I've seen it actually in court with clients where we walk out of court and the client's focused on one thing the judge said and they didn't hear anything else. And I'm like, well, wait a minute, you missed what was really important. And so we tend to I think a lot of us have a tendency to hear what we want to hear, especially clients. And so it's on us to make sure that the message that was sent is the same one that's received. And that is, to me, oftentimes litigation is a product of that challenge right there, where just a miscommunication, a message that was sent is not the same one that was received.
Yeah, and that goes to, obviously, the communication. Again, our job is to convey our position, but to make sure, not just to presume that the other side heard our message.
Right.
But to confirm that we're on the same page, right?
Yeah.
I had a lengthy call yesterday on discovery, whatever, and we were talking, and as I was listening, I said, well, hold on. It seems like we are talking past each other on an issue. So can we go back to that and we were.
Right.
But we were completely talking about two different things. as if the understanding, like the other side's view was we wanted certain things. And my position, I said, I don't understand why the volume is so large. I don't get it. And we started talking, we kept going. And then that's why I put a halt to it. And I said, hang on a second. Can we go back for a minute?
Right.
Let's start with the premise. And then we ended up sort of on the same page pretty much, because you have to listen and make sure. And I was under the impression that the subpoenas and the document requests were very straightforward and we weren't asking for this, but there was a nuance in there. And so...
Right. Sometimes the language is subject to different interpretations.
Thankfully, we were on a video chat and we just hashed it out and hopefully working towards a resolution. But the point is listening and talking, but you have to listen.
Yeah. I mean, and I think that's one of the reasons why we favor video and phone over email, because there's no inflection or tone. Yes, you can use bold or underline or whatever in an email, but it's not, the words are literal and we can read words. This happens in text all the time with people. And I think I was always resistant to the use of emojis, and I've come around. My family has, I'm a dinosaur. And so I now get the use of it because it does allow you to say, hey, I'm joking here, I'm being sarcastic or whatever. But in writing in an email, we don't have emojis or colors or themes or anything else to let people know that the language should be read in the manner that we intend. And oftentimes they're not. And we've seen it dozens of times in cases where the case goes off the rails because somebody sent an email and it was misinterpreted by somebody else.
Well, that's a good point. And, I know we're kind of wrapping up this conversation, but sarcasm does not come across well in black and white.
No.
I've seen it go horribly wrong in an email. You better know the other side, whoever you're sending that email to, the recipient, very, very well. And they better know you very, very well if you're trying to get sarcasm across in an email. It does not work.
Right. And joking too, same thing.
Yeah, joking.
And that's why we tell clients in depositions, don't make jokes, don't use sarcasm, because especially in a deposition, it's going to get transcribed and someone's going to be reading it later. And so now this joke that you made is just words on a piece of paper.
Yeah.
There's no humor conveyed there at all.
None.
And things can be taken out of context.
Right.
So communication, critical. Whether to do it, how to do it, what to do when you're doing it, all considerations, in our view, honest and open and transparent communication is critical. Better to over communicate than under communicate, and use both of those ears, not just one.
As always, well communicated, Jeff.
Thank you, Brett. If you enjoyed this podcast, this episode, please give us a review, hopefully 5 stars. Share it with your friends and family. Follow us. And if you want to reach out to us to be a guest or recommend a guest for the show, please do so at fastamron.com. Thanks.
For more information on this show and other resources, visit fastamron.com and connect with us on LinkedIn, Facebook, and Instagram at fastamron.